when the question is there.
But it's not a challenge. Yeah, it's an interpretation. It's not a challenge. On challenge, of course, you have to hear the Attorney General. Otherwise, wherever Central Act is involved, we'll have to start hearing the law officers for the government. We should, I mean, in a given case, you may find it necessary to
ultimately,
do so.
Lordship have to read down a provision of the Central Act. That is my, if Lordship permission, if I may read that.
And fortunately, solicitor is already here, not necessary.
That judgment is not necessary. That was the Bhuyan judgment of 2023. Judgment is of Justice M.
Give us the citation.
Lordship. Well, the reference order is of 2015, 12 SCC.
2015,
12 SCC, 702.
704.
702, my lord.
Yes.
And my lord,
what the party?
My lord, the party is Arup Bhuyan versus State of Assam. That is in 2015. Thereafter, my lord, it was answered recently in 2023, just before Justice Shah retired, my lord. The SEC citation is not there. Online citation is there, my lord. 2023 SEC online SC 338. Your Lordship permits, I can just read one paragraph where it has been answered. So I'm reading paragraph 64. Now, so far as the reading down of section 10A1 of UAPA 1967 by this court, in the case of Arup Bhuyan is concerned, at the outset it is required to be noted that such reading down of the provision of a statute could not have been made without hearing the Union of India and or without giving any opportunity to the Union of India. 65 minutes, when any provision of parliamentary legislation is read down in absence of Union of India, it is likely to cause enormous harm to the interest of state. If the opportunity would have been given to the Union of India to put forward its case on the provisions of section so-and-so of UAPA, the Union of India would have made submissions in favor of section 10A of the UAPA, including the object and purpose of the enactment of such a provisions and even the objects and purpose of UAPA. The submissions made by Shri Parikh, learned senior counsel, relying upon the decision of the court, Sanjeev Coke, that it is ultimately for the court to interpret and read down the provisions to save any provisions from declaring as unconstitutional is concerned. It is true that it is ultimately for the court to interpret the law or particular statute. However, the question is not of the power of the courts. The question is whether can it be done without hearing the Union of India. This has been answered in affirmative in para 100.
This was a case where otherwise the provision would have been unconstitutional. Therefore, it was read down to save it from the vice of unconstitutionality.
There was a specific.
So when a challenge is to a provision on the ground of unconstitutionality, in any case, if it's a central statute, the Union of India has to be heard, the Attorney General has to be heard. So necessarily, when you are reading it down, equally you have to hear the AG. So this will not apply here really. And that was a case where, there was a broader power to arrest. That was challenged as unconstitutional. That was read down by the bench in the early judgment. That's right.
Now, coming back to the coming back to my submissions, my lord. Yesterday, my lord, I was reading the table which categorizes the vehicles in two categories, that is transport vehicle and non-transport.
Yes.
So the point I was making, Lord, the motorcycle for hire to carry one passenger. This is the
Which page of the submission are you on now?
it's page 7. There's a table, Lord.
Yes. Yes, yes.
Point 3, Lord, I am stressing upon. There are about 21 categories of transport vehicles and 15 categories of non-transport vehicles. This is a table for the purposes of section 41 of the MV Act, which provides for registration of vehicles.
So what is
My
the submission?
submission, if the motorcycle whose weight would not exceed more than 200 or maybe 200 kilos with a pillion rider is categorized as transport vehicle, and there are SUVs which can be driven by LMV license, which have the weight of anything between 2,500 kgs to 5,000 kgs below. And every day we see accidents from SUVs. And I think that in my humble
So
submission,
according to their large SUVs, or heavy SUVs, which can be
Yes.
driven with a. On the other hand, there are smaller transport vehicles.
yes,
Each one, Devvrat, must be seen in the context. If you see subsection 4 of section 41, the purpose and object of such a tabulated form is only, as it says, it shall also specify the type of motor vehicle being a type as the central government may having regard to the design, construction and usage of the motor vehicle by notification in the official gazette. So the registration provision requires different facets to be recorded in the registration.
that's it.
And apart from other things, it also says the type of things which are required to be recorded is specified in here.
That's it.
And
So the
ultimately, the
context is slightly
Exactly. Context is very different and the purpose of the use is different. After all, a transport vehicle is used for a very different purpose than even say a large SUV. You're right. I mean, but as it is always said that these these aberrations cannot result in the provision being declared unconstitutional, even if there were a constitutional challenge. But more importantly, these are, of course, there are these exceptional cases where you will have a small transport vehicle as opposed to a heavy SUV for which the driver. But look at the purpose. Somebody who is driving an SUV, the presumption which the law makes is that you're not driving it for, it's not in the nature of, say, a school bus, or you're not driving it for carrying of goods or passengers for hire or reward. The purpose is very different. The nature of the people who are in the car is different. In the sense that, in one you have passengers who come in for hire or reward.
In my humble submission,
you would want us to interpret on the basis of this. This is an executive order. But we are really looking at,
The
I mean,
statute.
it might be even wrong. Let us assume for a minute that this prescription or categorization is contrary to the statutory scheme. But then to use this to interpret the statute will be, reversing it. Your purpose is to only for interpretation, right?
Lordship, please.
That we should not be doing it. We can't
So my
interpret the statute.
limited submission is this.
Executive interpretation. Motor Vehicles Act.
What happens if this is categorized as transport vehicles, and tomorrow, if unfortunately this vehicle meets an accident, and just because the person is holding an LMV license, he will not get the claim. The claim will be repudiated, even if it is a personal vehicle.
doesn't. License, it doesn't. This execute doesn't entitle somebody for a licensing or licensing. It doesn't work like that.
I mean, just to Milord,
No, no,
show
fine.
what is transport and what this is the only place where it has been categorized as transport and non-transport vehicle. Where Lordship will find a personal vehicle also being categorized as non-transport vehicle, which would ultimately come to the rescue of person if he is driving it or using it as a transport vehicle, and if it meets with an accident. Able to recover his claim and say that the vehicle was for personal use.
But one other thing, any of these under the non-transport vehicles are used for purposes other than a personal purpose, then the other provisions, statutory provisions get retracted. So it's not applicable across the board
I
to
appreciate.
define a non-transport.
I appreciate.
Okay.
This is the only distinction in the act.
How do you formulate it in your submissions? Let us see your submissions so
Not-
that we'll then you can leave the point after we've
Not-
read your submission on this.
Because I was reading para 5, Milord,
Para 5 already.
page 2. It is clear that legislative intent is clearly to replace above said classification with single class of transport vehicles. This was 94, Milord. Thus, the expression transport vehicle would include only the heavy goods vehicle as in section 216, heavy passenger motor vehicles as in section 2, clause 17, medium goods vehicle as in section 2, clause 23, and medium passenger motor vehicles as in section 2, clause 24. However, the classification of LMV remains unchanged in section 10, clause 2D as a separate class. In fact, Milord, Mukund Devankan also holds similarly. Para 6, therefore, the three-judge bench in Mukund Devankan has rightly held that the legislative intent behind the omission of clauses E to H from section 10(2) of the MV Act 88, insertion of expression transport vehicle in section 10, clause 2E, is to give effect to the provisions of section 3 of the Act, which requires that a person, in order to drive a transport vehicle, must have authorization. Once a license is issued to drive light LMV, it would also mean specific authorization to drive a transport vehicle or omnibus, the gross vehicle weight or motor car, road roller or tractor, the unladen weight of which, as the case may be, does not exceed 7,500 kgs. As I started Lordship yesterday, everything boils upon the weight. And till date, my lord, this regime, my lord, since 1988 till date, about 40 years, it's holding ground. It's only
So your
weight based.
contention really is, Devrat, that therefore, after the amendment, interpret the expression transport vehicle after the amendment in section 10(2)(E), so as to exclude those transport vehicles which fall within the definition of light motor vehicle.
Lordship. That will create problems. And
No, you are saying don't if you include all transport vehicles
absolutely.
in 10(2)(E), including those which otherwise fall within the definition of LMV, then it will create this anomaly which you said that even small transport vehicles would be within the ambit of the statutory provision in 10(2).
That is what my contention, my lord. Then para 7, my lord, LMV license means a license to drive a vehicle weight not exceeding 7,500 kg, which would also cover a vehicle which happens to be carrying any goods kept therein. For instance, where a person having an LMV such as Maruti van is carrying goods for personal occupational use. That was my contention.
Parliament has to step in and amend. One.
Originally, my lord, it was 6,000. By way of amendment, it was increased to 7,500. The weight. Right, my lord, I'm reading. Therefore, the expression LMB would extend over vehicles which happens to be carrying household goods and other goods of daily uses, such as certain professional like medical equipments and all, for doctors, even for lawyers, my lord, books and files, and for people like who do interior decorations and all, who routinely carry goods in their personal vehicles. If all these vehicles happens to be transporting goods which have their weight less than 7,500 kgs are classified as transport vehicle, then in that case, large number of insured vehicles of the country like India would stand to lose the insurance benefits on the pretext of being a transport vehicle. If in case such vehicles are found to be carrying goods in it.
You have written in para 8, say, medical equipment, doctor. But the Chief Justice of India is working very hard to take away files and books for the lawyers to qualify as a goods vehicle.
I was coming to that.
You don't have to carry all that big burden.
Lordship, we remember those
Justice
days.
Narasimha's car would have been much lighter now if he was at the bar. He would have been carrying only his
Earlier, transport vehicle.
a transport vehicle he would require earlier.
Lordship, there used to be thousands of bags outside. Now we see much lesser bags.
Yeah, you think it's been it's impacted, no?
We used to have trolleys
Yeah.
hauling the bags.
Even for us over here, there used to be in the morning when we used to come to the court, you would see there were these contractual staff carrying stacks and stacks of files on their shoulders. Then we say, what is this? At some point of time, their shoulders will give way. Then they had trolleys. The trolleys would be lugging all the briefs. Trolleys also come down now.
Trolleys came much later.
The airport, people used to have an objection because weekends when judges go out, baggages used to go out for files.
Yeah,
Huge baggages.
One particular, perhaps Chief Justice would recollect also, Senior Advocate Govind Mukhoti.
Yes.
He used to carry his own.
Yes,
Yeah,
yes.
Mr. Andyarjun also, my senior.
And the Arjun
Mr.
also.
Andyarjun now carries green satchel.
He's actually embroidered that.
Yeah,
Yes.
embroidered.
Milord, he was my senior also. So sometimes we used to help him with the bags and
Devrat was with Mr. Andyarjun also.
Yes, but he used to say, no. Let me also hold one side of the bag. So that was his style.
Of time.
In
That
fact,
old tradition in Mumbai came because the chambers were very close to the court, right? So the lawyers would carry their own brief and go to the court with the brief in hand.
Mr. Andyarjun used to say that Mr. Sirvai used to carry all his briefs.
All his briefs himself.
And sometimes he used to travel in the local train also, carrying his briefs. great thing, because he used to have just one matter a day, not more than one. He used to take just one matter.
And there was another tradition in Mumbai. You see, they used to have those bags, the brief bags, which were embroidered, no, with your initials. So if you performed well in a matter, the senior would present you with a brief bag which your own embroidered. So nobody bought those embroidered bags themselves. You see, you waited until a senior recognized you. It was one of those traditions. The senior would recognize you for. And it was always blue for non-designated seniors and red for designated seniors.
Designated.
Like the gown.
It was always a gift from a senior.
You have to earn your spurs.
Yeah,
as
the
they
gown
would
was
say.
always presented.
Even the gown also.
Gown always was presented when you became designated.
Mr. Andarjuna got a gown from Mr. CJI.
Likewise, I got my gown from him, when I was designated.
So many of our juniors who came later on, he said the gown is torn and all. Why don't he change? I said, never tell him to change. He'll never change it.
Just as Nagesharao gave mine.
Oh, I see.
The senior gown.
So 8 is over there.
That's it. I was
Nine
reading
come
the
to nine.
bottom.
9 now we'll take.
Para 8, my lord. I was just finishing. Therefore, in my respectful submission of the respondent, criteria of weight is important to distinguish between transport and non-transport vehicles and grant of licenses to drive such vehicles.
It could be one of the criteria. You can't be saying the criteria because there are so many other, say, licensing regime. It has very distinct between the two categories. So you can't say that this should be the only factor.
Well, my submission, humble submission, my lord, the LMV and HAV are the two, in the licensing regime, are the two great distinguishing factors. For LMV, it is different. The whole contention is revolves around LMV. HMV, it is different because of the load factor. It's based on weight only. Para 9, madam. In difference to the contention of the petitioner with regard to the compliance of section 7(1) of the MDR for driving a transport vehicle, it is respectfully submitted that as per the definition contained in section 221 of the Act, LMV includes a transport vehicle which does not exceed 7,500 kg, and therefore a person holding a license to drive an LMV is deemed to be authorized to drive a transport vehicle which does not exceed 7,500 kg in weight. Thus, a license to drive an LMV issued under section 10(2) also extends to driving a transport vehicle in the same weight category as provided in the bill.
The table at 10 you have already discussed.
10, I've already discussed.
Go to 11.
11 is respondent humbly states that the legislative wisdom has correctly defined the transport vehicle weight up to 7,500 kgs as an LMV and can be driven by a person who has been issued a license for driving an LMV. This honorable court in a decision under reference has correctly interpreted the meaning of the transport vehicle in consonance with the intention of the legislature as laid down in section 221 of the MP Act 1980. But in order to substantiate my arguments, the few paragraphs of the judgment, I'll read, where it has been fairly rightly articulated that how 221 is an important aspect of the Act and it cannot be overruled because of other provisions.
Which paras they were?
Para 17 in the middle, I will read. Placetum C.
You're referring to what exactly? I couldn't get that.
I'm only the
Judgment. You're talking about some judgment.
Lordship, the Mukund Devangan judgment.
Mukund Devangan.
I'm sorry. I'm reading para 17, Lord. 17. That is at page 74 of Mr. Dave's compilation.
Which is worrying is thing which is worrying,
Troubling
that,
also.
which is troubling, that apropos what Mr. Devrat argued, Mr. Kaul, the result of this would be that all those transport vehicles which fall within the ambit of the definition of light motor vehicle and which are less than 7,500 kgs by weight, they will all get out of the insurance cover. So smaller transport vehicles. If we take this construction, which you have suggested, which prima facie, I mean, we indicated to them also is a correct construction, but can't ignore the fact that then they will lose the insurance cover completely. Smaller
The vehicle will not lose the insurance cover. It is only when it is driven by somebody who only has an
That's what we are
LMP
saying.
license.
That there will be no insurance cover if the driver was basically a driver of an LMV.
That
But
will
the
happen.
moment it is driven by a driver,
Say Maruti van.
That will happen, my lord, in every case where a driver who doesn't have the correct kind of license drives a vehicle for which he is not authorized to drive. In every case, that will happen. So therefore,
no, it's a driver.
It's the driver who's not validly authorized to drive the vehicle for any even a transport vehicle above 7,500. Manoj, if a person who is not entitled to drive, whether under or over, is driving a vehicle of a class that he is not authorized to drive,
But
it's
then
not the vehicle at
people-
all.
No, not the vehicle, you're right, but I said that by mistake, but the consequence would still be that
he is not
people
having
who are
the
affected by an accident involving a vehicle which was driven by a person who only had an LMB license and therefore by necessary implication excluded from driving
therefore,
a
I have a suggestion.
small transport vehicle.
Your lordship's concern is
Lose
right.
the benefit
Although that is
of,
not something that will happen.
compensation.
Supposing you drive a large bus which is more than 7,500 kilos, the same thing will happen. If you drive it with an LMB license, you will not have the insurance cover. That will always happen if you do not have the correct license authorized to drive that vehicle. Now,
But within 7,500,
correct.
within 7,500, Mukund Devangan would have extended the benefit
Right.
of
So therefore, I had a
the
suggestion.
remedial provisions of the Act.
I had a suggestion, my lord. Your lordship yesterday mentioned about prospective overruling. Now, so that it is made clear that henceforth, in any case, you cannot with an LMV licensed drive a transport vehicle. But in prospective overruling, there are two things that I was suggesting. One was that where some court has given you compensation which has been paid, that will not be reopened. Nobody will have to give back that compensation. The other was because of the confusion that Mukund Devangan created in 2017, people may have been thereafter thinking that they are authorized to drive with an LMV license, a transport vehicle less than 7,500 kilos. So if the accident has happened between the date of Mukund Devangan and your lordship's my lord judgment, in case my lord it comes in our favor, then that will not be governed by my lord your lordship's judgment, but will be governed by Mukund Devangan. These are the two
Classical
exceptions.
prospective.
Yes, so these are the two exceptions, namely my lord, one. Yes.
Knowing in life, it's not unimaginable that light motor vehicles get to be driven by persons who have only non-transport licenses. It's possible. In all such cases, even if we say by prospective overruling,
Lord, it
that
is,
situation emerges and continues to happen in the country.
it may
So
happen
in
that
all such cases,
heavy
insurance
motor vehicle
company
is
will
also used
refuse
my
to
lord by a
grant-
person.
Insurance will say
In
that
all
well, I
such
can't take
cases-
compensation.
But we are contrasting it with the realities of life. So in
Not the
reality, this is what is going to happen,
Yes.
that somebody will drive a transport vehicle, light motor vehicle. Though we have declared the law, but that's going to happen. invariably somebody will.
But that surely, my lord, that.
And a large number of cases will be there, but that segment of the
So
population.
my answer to that is
Lose
that
it.
that cannot, my lord, determine.
We
There is,
understand that.
there is a
We are
defense.
only
And legality, we are
flagging
just impact, we are the
flagging a
consequence.
concern.
Correct. That's why I was saying, my lord, that your lordship's concern may be valid to the extent that because of the confusion created by Mukund Devangan, people have been driving it thinking that they are authorized to drive it. So that class of cases can be accepted. Otherwise, my lord, a person having no license can drive a vehicle.
Absolutely.
It happens, my lord, many people drive without licenses, even though the car is insured. Now, can it be said that, well, because of that, the insurance will not be valid,
On
therefore,
interpretation, we don't need.
I'm not just on the interpretation, I'm on the impact of it also. Lord,
But
the
also you
whole
are-
point is the insurance company has insured the vehicle saying that I am giving this insurance only if a person who's competent to drive this vehicle drives it. Otherwise, I'm not insuring it. So therefore, my lord, can the insurance company be told, sorry, even though you insured it for a person having a valid driving license, but it happens in life that people without driving licenses drive it, so the insurance will have to be.
We can reduce the legal license, it's going to be prospect.
Section.
The only way out of it, that your lordship may have to give a window period after the judgment, get the license.
Prospect only is enough.
In fact, my lords, what will happen here?
Publicity of the.
What your lordship is
requirement.
suggesting will actually encourage people to now take an endorsement on their license, which was till now not being taken. That will also be with publicity. And if your lordships are to vote in our favor,
And to
would
get an
encourage them to
endorsement.
take an endorsement.
To get an endorsement, it is like, upgradation.
Yes.
So you need to undergo the training, you need to undergo the health checkup and things.
Like, otherwise the impact would be on the day of the judgment, there would be lots of people who will go jobless, especially people who are driving Uber and all, my lords. Ola, on the strength of the LMB license, jobless the day the judgment comes out.
Do that in 4 months.
There's a social angle to this. But there is a social angle to this. The point I am making is.
But please see section 150. Section 150 is a defense which is made available by the statute to us, which says that if you do not have a valid driving license, then the insurance policy will not be valid.
Right.
That all we are with you, Mr. Krishnan. There
I'm
is no
sorry.
difficulty on that. We are not.
So therefore,
not against you on that.
the moment your lordship says that even though a transport vehicle will not fit within the contours of LMV, and if you have a license to drive an LMV, you will not be authorized to drive a transport vehicle. But if you have done so, the insurance policy will still be valid. That would be totally contrary, my lord, to the provision of the Act.
That we have heard you, I mean, now. Yes. All right, let's, Mr. Devrat, complete. Devrat, now we've seen your submission. Anything else that you want to?
Lordship, I just want to read few paras.
Para 17, you've noted.
Yes, we've noticed that.
Custom C, I was reading from the middle. The provision of section 3 of the Act requires that a person, in order to drive a transport vehicle, must have authorization once the license is issued to drive motor vehicle. It would also mean specific authorization to drive a transport vehicles or omnibus, the gross weight of the motor car, road roller or tractor, the unladen weight of which, as the case may be, does not exceed 7,500 kg. The insertion of transport vehicles category in section 10(2)(e) has no effect of obligating the already defined category of transport vehicles of the class of LMV. The distinction is made in the act of heavy vehicles, heavy passenger motor vehicles, medium goods vehicle, and medium passenger motor vehicles on the basis of gross vehicle weight. That is by contention, Milord. Or unladen weight for heavy passenger motor vehicles, heavy goods vehicle, as the case may be, exceed 12,000 kgs. Medium goods vehicle shall mean any goods carriage other than LMV or HMV, whereas medium passenger motor vehicles means any public service vehicle or private service vehicle or educational institution bus other than a motorcycle, invalid carriage, LMV or HMV.
Made a minute. Thank you, Ms. Devrat.
Lordship, just one paragraph, if you
Yes.
may.
We'll hear some, yes.
Milord, para 39.
Para 39 of Devangan.
Devangan, Milord.
All right, we'll make a note of that.
Then your Lordship may kindly also, Milord, make a note of para 55 and 58.
Okay.
Milord, 39 actually summarizes everything, Milord.
Yes. Thank you, Ms.
Lordship, thank you.
Yes, thank you, Mr.
Thank you, Lordship.
Yes, Mr.
May please, my lordship. My submission will be, my lord, basically twofold. The first part of the submission is on the very basic interpretation of the definitions and the provision under the Motor Vehicle Act. The other fold of the submission will be on the point that the impact is already secured. I will point out that as well at the end, ma'am.
So first, what is the first?
So
submission?
if my lord would please have a fresh look on the aspect of the definition. So if we have a bird eye view on the definition aspect, so we have a class of vehicles which is as per the weight. We have a definition of a light motor vehicle which is up to 7,500. We have a definition of heavy goods vehicle and passenger motor vehicle, heavy passenger motor, which is in section 2 clause 16 and 2 clause 17, which is also exceeding 12,000 weight. We have a class of medium goods and passenger vehicle, which is defined in section 2 clause 23 and 2 clause 24. There is no specification with respect to the light goods vehicle or light personal vehicle, light passenger vehicles. And my lordship, all these definitions are very interconnected as far as the weight is concerned. The other aspect is the kind of vehicle and the name of vehicle. So if you have a bird's eye view, as far as the definition is concerned, we have a class of vehicle which is purely on the basis of weight. We have a kind of vehicle. And we have a name of vehicle. It is interesting to note that the name and kind of vehicle does not specify any weight in it. There is no there is absolutely no mention of weight in the name and kind of vehicle. I will take, for example, my lordship, if we see section 2 clause 21, my lordship, may I please see the act, ma'am.
Have you formulated it, Kaustubh?
My lord, I have
No, what you're saying,
my
have
written
you
submission, but
formulated-
in a very short form, but I'm just expanding it, ma'am.
No, I'm just asking, have you formulated what you said? No.
Yes, ma'am.
You've given us written submissions?
There is, my lordship. But my lordship, what I am right now, argument is beyond my written submission.
Yes, you got
Okay,
it.
then you can go
So-
ahead.
Now tell us, just to take it forward, you're
Yeah.
saying there
Three
are
categories.
three categories.
This is section
Class
2
of
clause
vehicles,
21.
what class of vehicles based on weight? Just give us which are those provisions so that we can
Yes,
just
ma'am,
take
please.
it.
Section 2 clause 21 first, it is for LMV, which is up to 7,500.
Just give the numbers.
Yeah.
Yes, yes.
221, then?
216 and 217, 223 and 224. And all this definition is very perfectly interconnected, my lord.
Okay,
to every
now, so
point.
far as those vehicles which are go by name, non-weight, what are
yes,
those?
ma'am.
A kind of vehicle without reference to weight. That's the second thing. Which is that?
Yes.
Kind of vehicle without reference to weight.
My lordship, first is the transport vehicle,
Clause.
247. There is a tourist vehicle, 243. There is a tractor, 244. There is a semi-trailer, 239. There is a private service vehicle, 233. There is omnibus, 229. There is motor car, 226. There is a motor vehicle which is in general definition 228. And there is goods carriage, 214.
214.
Yes, sir. So, my lordship, may see in all this,
These are kinds of vehicles without reference to weight.
without reference to any weight, there are kinds and names of vehicle without reference to any weight.
Names and names.
So,
Together.
the main benchmark for identifying a class of vehicle is weight. And after the definition provisions, the whole act has to be interpreted considering the weight of the vehicle. Before that, my lordship, I will just point out by way of an example at how perfectly it is interconnected. If my lord may please see section 2 clause 21, which means a transport vehicle, as defined in 247. Now the transport vehicle means a public service vehicle, which is also defined as to what is public service vehicle. And public service vehicle also finds mention in 217, which is the heavy public motor vehicle, and also finds mention in medium public motor vehicle, medium passenger motor vehicle. So it finds mention in a weight category between 7,500 to 12,000, which is the medium public motor vehicle, and it also finds mention in the weight category above 12,000, which is the heavy public service. So much likewise, even the education institute bus. Let's take the other example in the definition of 247. So the education institution bus also find mention in 217, which is the heavy public service vehicle, and it also find mention in 224.
What you're saying is there is no very, very clear distinction between vehicles based on weight and vehicle based on name and,
It is very clear distinction
Right.
only on the basis of weight.
so they are all integrated. So what's the sequitur?
So much like the significance is going to be the interpretation of the further provisions in the act based on the definition. So as per the bird's eye view about the definition clauses, the definition is primarily a basic classification on the basis of weight. We have a classification up to 7,500. We have a classification from 7,000 to 12,000, and we have a classification above 12,000. the interesting part is that everything which is defined is already defined in the uh, in the definition clause as well as it's defined mentioned in the class. So definition is also there, and the very same kind of vehicle also find mentioned in the class. If I am able to make my
Which
point.
is the category of 7,500 to 12,000?
It is a medium. My lord, may please read 223, for example. Means any goods carriage, so much goods carriage is also find mentioned in 247. Means any goods carriage other than light motor vehicle or heavy goods vehicle. So light motor vehicle is up
To
to
7,500.
and
Heavy
heavy
is
goods
above
vehicle is
12.
216 above. So there is a very perfect categorization. And in order to further expand the example, let's take the another example from the definition of light motor vehicle. Let's say omnibus. So much omnibus finds mention in the category of light motor vehicle, but omnibus also finds mention in 217, which is the heavy passenger motor vehicle. And omnibus is also defined in section 2 as to what exactly is much omnibus. It is defined in 229. So much likewise, the kind and name of vehicle which is defined in the whole definition scheme of the act has nothing to do with the weight. Weight is a separate classification altogether. Because we find a very common name in across the class of all the vehicles. If I'm able to also satisfy my lord. Therefore, my lordship, let's take example of motor car also.
What you do is, you have good points you have raised. But
Formulated
that doesn't
for
seems to
mistake.
be existing in the written source.
I will
Reformulate it
Yes, I will definitely.
along with these sections and then give it to
I
us.
will
then give it to us.
because all these sections are very much interconnected.
No, I know, you are,
I will
you are
just put it
you are
down
showing
on a
it in
piece.
a different kind of a scheme. You formulate it for us.
I will do it, my lordship, and I will. And therefore, the definition has to be seen in a bird's eye view. It can't be seen in isolation. The definition of a transport vehicle, all only a definition of a light motor vehicle.
You have given us
Every-
that now, those classifications, yes.
Because every word mentioned in the definition of light motor vehicle is already defined in the other provisions.
Anything else? Give it to us.
Yes, my lord.
About 2 or 3 more pages
Well,
linked to your own submission. Let's share it with the others.
But other part is, as far as to understand section 3, 4, section 3, 4, 5, and 6. Actually, what we need to understand first is section 7. My lord, may please see section 7 for a moment. It is the restriction on the grant of learner license for certain vehicles. So it specifies that it is the restriction for grant of learner license for certain for a certain vehicles. And what are those certain vehicles is to be inferred because the word uses transport vehicle unless he held a driving license to drive a light motor vehicle for at least 1 year. So like if a person wants to so basically, if a person wants to apply for a
Let's not militate against your submission. That means you
E-
can't get a learner's license for a transport vehicle unless you have a light motor vehicle license and you have held it for 1 year.
light motor vehicle, as per the definition, which include a transport vehicle up to 7,500.
Right.
So it is very clear that so like the basic restriction which
You are saying
section 7 is talking about.
7 also read it as exceeding 7,000.
Because it has to get measured because the word transport vehicle is already defined in section 2. And therefore, the appropriate interpretation in my submission will be.
So you are trying to, therefore, this section will have to be recast.
Yes.
No person shall be granted a learner's license to drive a transport vehicle, bracket, which does not fall within the definition of a light motor vehicle,
Yes.
bracket complete, unless he has held a driving license to drive a light motor vehicle for at least 1 year. So we'll maybe reading in some provisions into the statute.
No, because the plain reading of Malfi, this section says that a person is already having a
So Devrat was saying that interpret 10(2)(e) also in a different way, therefore. So you're now saying, look, 7 also will have to be slightly structured in
because
interpretation.
the person is going to apply, he's already having a driving license so it is therefore.
Only if your transport vehicle exceeds 7,500 in weight, that this prohibition in section 7 comes into effect.
Yes, but if a person is applying for driving a transport vehicle above 7,500, because the word light motor vehicle is here. He hit the word. So Malaysia, they have consciously put the word light motor vehicle here. So they've consciously put the word, and Malaysia, a person must be having for 1 year. So a transport vehicle, as per section 7, is a transport vehicle which is above 7,500. It is not a transport vehicle which is having the same meaning as LMB.
Give us this.
Yes.
So really
So after-
speaking, we will have to rewrite all those provisions of the statute now, including those for medical certificates, etc., to mean that those will apply to only those categories of transport vehicles where the weight exceeds 7,500.
Actually, my next part is on the medical certificate also. And so much, if we read the section 8 and 9, if we see the pattern, like in which section 8 and 9 has been drafted, we see a very similar pattern. Up to proviso number 6 and 7 of the respective sections, they deal with the transport vehicle. And after the proviso, they deal with the light motor vehicle. And my lordship, if we read subsection 1, which says that it is subject to restriction mentioned under section 7. If my lord may please read the first proviso of section 8. Any person who is not disqualified under section 4 of the driving motor vehicle and who is not for the time being disqualified for obtaining a driving license may subject to provision of section 7. And interestingly, if my lord would see the subsection 3, it says every person to drive a transport vehicle under subsection 1. So, my lordship, basically subsection 3 is it taking you in a reverse gear to subsection 1, and the subsection 1 is taking you to subsection 7. Because, my lordship, it actually talks about the application. Application for. So it is therefore, my lord, basically section 8 and section 9 are, my lordship, they both have been drafted in a very similar pattern. It is very important to observe the pattern in which my lord, sections are also drafted. Because like like my lordship, section 8 clause 1 and 3 takes us back to section 7 in a very similar manner, my lordship. Section 9 clause 3b also takes us back to section 8 clause 3, and accordingly to the my lordship, restriction as far as a person is already having LME for a period of 1 year, only after that he can apply for
Formulate,
transport.
Mr. Shukla, you formulate now your
Yeah.
submissions. I
No.
think we'll close. We got the drift of your submission,
Yes.
but I would like to see a formulation by you. Yeah, give it to us. We'll
There
reflect
is,
on
my
it.
lordship, the other part of the submission is that
Because this is just typically one of those matters we require a written formulation, because
I
it's
will-
such
I-
a
because it
interplay
is
of
also-
very
because
intricate provisions,
the
it's
other part-
basically statute.
it has been drafted in a very well interconnected way.
So
I will
please formulate it.
I will
Give it to us.
Job, Kaustubh.
Because you would like to think over it, but just give it to us so that we can then
Yes,
have
yes.
something on paper which we can.
What
Yes.
else, Kaustubh?
Anything
I will
else?
do that. I will do
Thank
that.
you.
There
Anybody else?
there is also only 2 points which actually I want to make.
Just indicate, indicate.
Yes. So, as far as the definition of section 10, 10 to D and 10 to E is concerned, it also has to be read, considering a very holistic view of the definition clause. It is a very short summation. The other part is with respect to the rules. So, because it has been
Just
pointed-
formulate it, what you are saying on the rules, what do you have to say on the rules?
As far as the syllabus part is concerned, my lord, rule, my lord, 31J, if my lord may see.
What is your
there
formulation?
is, my lordship, no syllabus for a transport vehicle. The my lordship, syllabus is only for my lordship, light motor vehicle and my lordship, medium oblique heavy motor vehicle. There is no syllabus for transport vehicle. Therefore, to say that there is a different syllabus, it is, my lordship, not in consonance with my lordship, rule 31J, rule 31J itself.
All right, thank you.
Actually, my lordship, in my written submission, I only just want to point out because my lord is more concerned about the impact of this judgment, my lordship. If my lord would please see my written submission. The my lordship, concept of my lordship, third party insurance is introduced as per chapter 11 of the Act. It was introduced in the year 1994 by way of Amendment Act 54. And if my lord may please see page number 3 of my written submission, my lord. As per section 49, my lordship, which falls under chapter 11, its main object of the amendment is
Page 3.
page number 3, my lordship, my point number 5. Its main object is to provide the adequate compensation to victim of the road accident without going through the long drawn procedure. It is the main object of 1994 Act, and it is therefore there are 2 kinds of insurance. One is a statutory. One is a statutory insurance, which is as per chapter 11 of the Act. They have to have the statutory. They need to have the statutory insurance, scholarship. It is a compulsory. It is a compulsory third-party insurance as per the Act. It is not a contractual insurance, scholarship, where we take a comprehensive policy for everyone. It is the statutory insurance. And thereafter, the chapter 11 was further amended by way of an Amendment Act of 32 of 2019. And as per clause 2 of the statement of object and reason, the main purpose was to basically further quantify the loss of the family by losing its breadwinner. It is very categorically mentioned the object of the amendment.
I think, Kaustubh, what we should do is, you have some good ideas You will have to redo your written submissions.
I will do that, my lordship.
You reformulate this.
And my lord, for a simple reason that it is a basic law that the contract of insurance is a contract of indemnity.
All right.
So pay and recover, my lordship. The page number 7 is the pay and recover, my lordship, because the Swarna Singh judgment is a good law
All right.
as on date, and only the part which is, my lordship, basically I am worried, my lordship, with respect to the pay and recovery, because it is a settled law as on date. The 150 difference which they are talking about is, my lordship, subject matter of trial. They can take a defense, it is a valid defense, but the defense has to be proved before, my lordship, MSCT. And what we need to understand, my lordship, most of the MSCT matter, my lordship, like the victims are my lordship, underprivileged. And it is therefore the amendment of 1994 and also 2019 is in a way of beneficial legislation. And accordingly, the rules of interpretation has to go. So I will not expand on that because my lords are very
My lord,
Please, ma'am.
appearing in 501.1 and the formulation which my lord was referring to I might provide some assistance there, both regarding the weight and categorization. It's in name of Anuj Bhandari, my lord, 501.1 written submissions.
Two women.
501.1. Well, 501.1, I filed my written submission trying to formulate the point my lord just referred to. In the name of Anuj Bhandari, my lord has it?
Yes.
Yes, my lord. My lord, my first submission is, I won't go to the extent of saying that this reference has lost its meaning or it has become infructuous. But with passage of time, my lord, Mukundan was decided in 2017. 6 years since, my lord, much water has flown and things have now aligned in accordance with Mukundan. My lord. There have been 2 subsequent amendments which are before my lords. Mukundan was not interpreting those amendments. What Mukund Devgan was interpreting was 1994 amendment as it stood then. Reference here is Mukundan was wrongly decided. So if my lord is to check whether Mukundan is rightly or wrongly decided, you have to turn back wheel of time, go back to 2017 and check 94 amendment, which doesn't make sense because now the relevant provision has changed. In line with Mukundan, Mukundan said you exclude LMV from transport vehicle, make it its own category. This honorable court says that. Government does the same. I'll show how and when. And now can you say no, it doesn't mean what Mukundan says?
Show us what steps
Yes.
have been taken after
Yes.
Mukundan to reaffirm. If Parliament has affirmed Mukundan, then it's a matter
Not
of
Parliament, but practice and rules. I'll show that. My lord, may I have form, my lord, may I have form 4 as it stood when Mukundan was decided. My lord, may I have page.
Is it in your submissions?
No, my lord, it's not part of my submission. It's there in Mr. Dave's submission, page 75. My lord, may I have. This is Mukund Devgan has taken the excerpt of the form as it stood in prior to 1994. From 89 to actually 2001. The form was introduced later, amendment came in 94.
So this form 75 held the field between?
Form 4 was page 75. Form 4 was in existence from 1989 till 2001. What did it say? Page 75 of Mr. Dave's written submission.
Yes.
My lord has it? Yes. This is form 4. Look at the categories given: motorcycle without gear, with gear, invalid carriage, LMV, motor goods vehicle, medium goods vehicle, medium passenger motor vehicle, heavy goods vehicle, heavy passenger motor vehicle, road roller motor vehicle.
So it had EFGH basically.
Yes. So no reference of transport vehicle based strictly on weight. This will also lead to my next argument, but I'll come to that later. Strictly on based for good 12 years when the act came into force.
No, this categories, there is no reference to transport vehicle.
No reference to transport vehicle.
Nothing to do with weight.
Look, my lord may have this.
Yes.
Light motor vehicle,
Right.
medium goods
Its
vehicle.
definition.
So categorization for grant of license was basis of weight,
Correct.
not
Now-
on use.
Now let's see the amendment form.
Let's see the amendment.
Next page, my lord, go page 76. This form was introduced pursuant to 94 amendment. It was introduced in 2001. So the practice changed in 2001, and now it says motorcycle, invalid carriage, light motor vehicle, transport vehicle, and medium passenger motor vehicle. So
this was brought into conformity with 10.2.
yes, all of the mirrored forms mirrored 10.2. 10.2 was also amended. This form was also changed, and therefore, my lord, I'll submit that later. The genesis of weight remained. Change was only core nomenclature. It was just a labeling. You have to pierce the wheel and see what was behind it. What did it replace? Right. Now, my lord may have my written submission, and my lord may come to page 16. 15 first. So these two forms were interpreted by Mukund Devgan, saying that you have to read down transport vehicle and LMV would include transport vehicle. This is what Mukund Devgan says. Pursuant to that, in 2018, Mukund Devgan is 2017 judgment. My submission gives the exact date. I'll give it to 3rd July 2017, my lord. Very first line, rather. That is the date of decision, my lord. Pursuant to which, my lord, may have my written submission, page 15. This is a notification issued by Ministry of Transport and Highway. My lord, has it?
Yes.
My lord, the third paragraph I'll read of the notification main body. And whereas copies of the said gazette were made available to public on 29th August 2017, a draft notification was issued. And whereas no objections and suggestions have been received from public in respect of the said draft. Now let's go to the form. This was in 2018, 20th March 18. This is the form which changed. What are the categories? Page 16, my lord, class of vehicles.
This is form 2 now, is it?
Yes, form 2. It is. Earlier it was form 4 and 6. 4 was for application, 6 was for giving license. Now it has merged into form 2. My lord, has it? Page 16?
Yes.
Yes. So categories are motorcycle, 2 of them. Motorcycle and e-rickshaw, my lord, I'll deal separately. Let's just focus on light motor vehicle as non-transport vehicle. It was never there.
What is it? Light vehicle, motor vehicle as non-transport.
Light motor vehicle as non-transport vehicle, invalid carriage. Light motor vehicle as transport vehicle. Then this is critical. Medium or heavy goods or passenger vehicle as transport vehicle. So in 2000 form, it was just transport vehicle. So the confusion whether it includes LMV or not. Today, before my lords, this is what is to be interpreted.
So it says light motor vehicle as non-transport vehicle.
There's scope for interpretation.
So it says light motor vehicle is both bifurcated into non-transport and transport.
Correct.
Right.
And medium or heavy vehicle as transport vehicle. This is further change. This is further change.
But no, but this indicates that you may have a light motor vehicle license, but you can't use it for a transport vehicle.
Now, transport. So you have a two kind of vehicle, not on the basis
LMV,
on the basis of
LMV NT.
NT, yes, on the basis of use, right? Not on the basis of weight. Correct. So it was so it means that transport vehicle were always included in LMV. Let it take it otherwise. So when today the license in my pocket doesn't say NT or T. It is in 2018. The licenses which were being shown this concept originated in maybe in some state they were giving, I don't know. But this concept originated in 2018. Prior to that, I was only getting LMV license, which always included transport vehicle. Because originally,
And after 2018,
yes, there was a bifurcation that you need two different licenses. To drive a LMV for transport, you need a LMV T, and to drive a non-transport, you need LMV NT. meaning LMV does not exclude transport vehicle. What have been argued by
But
them,
can we interpret the provisions of the Act on the basis of the form?
my lord,
In fact,
it's more of a practice.
alternative.
My lord, question here, that's
There is
an
one-
important
one
question.
place where Mukund Devangan is right, that you can't use the form to interpret the act.
As Justice Chinappa Reddy said, it's like the tail wagging the dog. Or the,
Correct.
instead of the
Like,
dog wagging the tail.
I have always
Head
held
and
the
shoulders
belief
spots, no?
that you can't even use the rules to interpret the act because otherwise that would enable the central government to change the meaning of the act if you were to use the rules. Correct.
So my lord,
Just one second.
my lord,
Government accepted.
Deleted.
my lord. My lord, what fell from my lord's question here is not just pure question of law in an academic manner which can be decided. Insurance companies are coming to my lord saying that all the driving licenses issued throughout India, people driving motor transport vehicle, though they are not entitled to any claim, the insurer, whoever the claimant is, and they want to absolve themselves. The question is, were these licenses given illegally over the years? It's not pure question of law.
Because of the rule prospective overlink, perhaps we may.
I'll address that
To
also.
that extent, it's all right.
Coming to this, my lord, today the way it stands is medium and it's not even today. This is 2018. So two categories given: LMV for T and LMV for NT, and then you got the specification: medium and heavy or heavy goods or passenger vehicle is transport vehicle. So that is it. Now, my lord may come to the next page. Sorry, my lord may come to page 20, annexure 2. This is 16th April 2018. They say government had an option to change the rule and maybe contrary to the decision of Mukund Devgan, because it's not writing on a stone that you can't change it. It was interpreting a 20-30-year-old provision. They decided to comply with it. This is a compliance order given to principal secretaries of all states, DGP of all states, accepting the entire finding of Mukund Devgan and last paragraph, para 3 at page 22. In view of the legal position as settled by Honorable Supreme Court in the above judgment, the requirement under Motor Vehicle Act to obtain the transport license was arise in case of medium, heavy goods and passenger vehicle only. No other vehicle will require any separate endorsement, even if they are used for commercial purposes. The exemption from requirement to obtain endorsement for commercial vehicle would apply to following vehicles: motorcycle with gear, motorcycle without gear, LMV, goods/passengers, e-rickshaw, e-cart. So let's just focus on LMV. Motorcycle and e-rickshaw I'll deal separately, Malon, later on. So they complied with it. Practice changed for last 6 years. Let's come to the next. Page 23, this is the third annexure, Malon. I'll read the second paragraph. There's a draft issued first. And the second paragraph, and whereas copies of the said gazette notifications were made available to the public on 29th May 2020, and whereas objections and suggestions received from public in respect of the said draft rules have been considered by the central government. Now in exercise of power, this. So objections invited, suggestions invited, received, considered, and what does the government do? Malord may have page clause, I'm sorry, Malord. Just have to give the page itself. Marked it. It's clause 50, my lord. Must just give me a moment. Yes, page 37, my lord. Page 37, clause 50. This is the change which is invoked today. This is the present status of the rule. Form 2, page 37, clause 50. In the said rules, in Form 2, my lord has it? Yes. In the said rules, in Form 2, in the table, in serial number 1 relating to the class of vehicle applicable for new learner's license or driving new license, the word non-transport vehicle LMNTV shall be omitted. Invalid carriage. C, the word light motor vehicle as transport vehicle shall be omitted. In the explanation, serial number 3, a transport vehicle shall be omitted. So, my lord may rather have the full form, which is at page 685 of Mr. Dave's WS. And how it reads today. Did it read the same way when Mukund Devan was decided or the reference order was made? Page 685, Manal has.
The bottom of the page, right?
Yes, starts at bottom of the page, Manal. Next page is, first is class of the vehicle applicable for new motor vehicle, light motor vehicle. So now the concept of T and NT goes away.
So this is a 2021 rule.
2021.
But licenses issued subsequent to 21 also
No, maybe.
has not been incorporated.
Maybe it's because states issue them, it might not have percolated by then.
So these are actually in the nature of rules itself, no?
And look at the transport vehicle, how is it used now and how it was used with Mukund Devangan.
Yes.
Medium or goods, heavy goods or passenger vehicle as transport vehicle. So concept of transport vehicle is no more with LMB. It is now confined to heavy and medium. No ambiguity. The ambiguity which was there before Mukund Devangan has been taken away. Because then there was transport vehicle and LNG. Now it is not there. And clause explanation 3, just to even clarify further, light motor vehicle includes, now you take away this has been omitted. Earlier this word transport vehicle. So now the concept of transport vehicle is confined to heavy and medium.
Read explanation 3.
Yes, my lord. Explanation 3. My lord, rather I'll read 3 of them. Non-transport and vehicle include motorcycle with or without side gear, mopeds, three-wheeler. Transport vehicle includes public service, goods carriage, educational, or private. 3. Light motor vehicle includes, there's an omission here, my lord. which the word here, which I read the original, the amended rules, omission of the word transport vehicle. So this word transport vehicle has been omitted here.
Yes.
So now it is very clear because of this exact provision that transport vehicle is confined to
Anything else?
my lord, there's few submissions, my lord, I'll take some time. My lord, something interesting falls from this proposition, my lord. It is pursuant to Mukund Devangan's judgment that these amendments have been carried out.
Yes.
Today, my lord, is to interpret these amendments, not 94 amendment. When my lord interprets this, which is pursuant to an interpretation already given by the court, can my lord today say no, interpretation is something else and not what Mukund Devangan said? That's one. Two, these rules are not under challenge. It can't be set aside. So in order to arrive at a conclusion given by the petitioners, my lord would have to set them aside, turn back wheel of time, go back to Mukundan's time, interpret 94 rules, and then come to a different conclusion. Today, that can't happen. That's one. Now, secondly, my lord may have my written submissions again. The classification which my lord was talking about, the weight category and different categories of classification, my lord, page 5, I've given a table. And I'll put forth how it works. The entire scheme of the act. Broadly to my mind, page 5, my lord, has the table.
Yes.
There are three bases of classifications. One is based on weight, which is LMP, less than 70, MMP, and HMP.
What we're thinking of was this, that in the light of what has been argued by Mr. Devrat, by you and Mr. Kaustubh Shukla, we'll issue notice to the Union of India because the Solicitor General has been appearing for the insurance company. We'll issue notice to the Union of India and request the Attorney General to assist the court because we would like to know whether post the judgment in Mukund Devangan,
Correct.
that they have accepted the judgment by making these amendments to the rules. In which case, we'll decide what is the impact, but we'll have to hear the Union of India in this.
Said that, but he didn't. Can't comment.
So let us hear the Union of India and.
We have no difficulty in that, but of course, what my learned friend is suggesting.
But let us hear, we'll not
no
conclude
difficulty.
the issue.
No difficulty.
We will just say during the course, we have heard in the course of the reference to the Constitution bench, we have heard Mr. Siddharth Dave, Mr. Prashant Bhushan,
Jan Bhujan.
so sorry. This is the impact of PILs on members. Mr. Siddharth Dave, Mr. Jayan Bhushan, Mr. Neeraj Kishan Kaul, and Mr. Learned Senior Counsel, and Mr. Tushar Mehta, Learned Solicitor General, assisted by Ms. Archana Pathak Dave on behalf of the insurance companies. Let's stop. Mr. Amit Kumar Singh has appeared on behalf of one of the supporting interveners. Let's stop. On the other hand, arguments have been addressed before this court by Mr. Devrat, Mr. Kaustubh Shukla, Mr. Anuj Bhandari, and we'll also say Ms. Anita Shenoy. All right. Yes, and Mr. Anuj Bhandari, who have taken the contrary position. Let's stop. Ms. Anita Shenoy, Learned Senior Counsel, will be adopting the same position. Let's stop. During the course of the hearing, one of the principal submissions of the respondents has been that pursuant to the judgment of this court of the three-judge bench of this court in Mukund Devangan, pura naam likh lijiye, was accepted by the union government by issuing a notification dated 16 April 2018, by issuing notifications dated 16 April 20, 20 March 2018, 16 April 2018, and 31 March 2021.
And thereafter issued the rules dated
31 notification dated 31 March 2021 in the Ministry of Road Transport and Highways, as a result of which the rules were amended. Full stop. We have the considered view that the position of the union government in the Ministry of Road Transport and Highways would be necessary to render full assistance to this court. Stop. We request the Learned Attorney General for India to assist the court in that matter. Now we'll keep this. You are returning. So we list it after the. 370 issue हो रहा है तो रख सकते हैं. We can keep it on the 13th of September, immediately after the, the article 370. Mr. Solicitor, we would like the assistance of the Union of India.
Yes, Manoj, I heard your lordship's issued notice to
give
the
us-
learned attorney general.
Right. So we list this on the 13th of September. What you suggested that is that Mr. Devrat, Mr. Shukla and Mr. Bhandari and as well as Ms. Shinoy, you can sort of tighten up your written submissions, and ideally if you can give us one set of submissions between the three of you, it will really be very nice, because you can exchange it between the three of you. Then sit down together and give us one, because then we don't have to go back and forth. Put whatever and whatever annexures you wanted to all four of you, so that this will just make it easier, because there's no conflict of interest between the four of you. You are giving us the similar viewpoint. Just put it together in one submission, and then to say that these are the submissions, joint submissions of all four of you. I think that will be better.
Although, Lord, the government had no option but to accept Mukund Devangan. So
Not
therefore,
necessarily.
even if they made a rule to bring it in line with Mukund Devangan,
We will not
the
resume that.
interpretation of the act will not depend on what the government.
We'll
Anyway,
keep
we'll address that.
the powder dry for what the government.
Yes,
has to
yes,
say.
yes.
Now, under Lord
We
section.
were hoping that we'll conclude it today, but now it's become a little more, yes, we need to at least hear the Union of India.
Your lordship consider
Not necessarily, that can always be. Will be here for the NCT matter right away, because we were wondering whether to sit at 2 or we can start right away.
Others may not be aware, Manoj.
We'll come back at 2 o'clock. We'll come back at 2 o'clock. So
I have no difficulty, Manoj. Your
Yeah.
lordship's convenience.
anyway, even if we start now, we'll have to break at 1. So we'll start at 2 o'clock. I think that's better. That's better.
All right.
Yes, sir.